What's going on with birthright citizenship? Welcome to Law and Society. Please subscribe. We're going to discuss that today because, first of all, after Donald Trump issued the birthright citizenship ban, there was a lawsuit in which a district court imposed a nationwide injunction to stop Donald Trump from imposing his birthright citizenship executive order. Well, the Supreme Court nixed that. The Supreme Court said that, no, you cannot have universal injunctions, and that it applies to only plaintiffs in the case, thereby cutting short the judiciary's power to check the federal executive, and by nullifying the nationwide injunctions, it in a way allowed Donald Trump to keep on depriving people of their citizenship, birthright citizenship, by way of the executive order ban. So what I'm going to do is just a reminder. The Citizenship Clause of the 14th Amendment, Section 1 says, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of states wherein they reside. It's pretty clear. The only part where there is some ambiguity is and subject to jurisdiction thereof. And Donald Trump's lawyers have pushed on that, we don't have jurisdiction over the people who are giving birth to these kids in the United States, and therefore they are not citizens. So the putative class that is being talked about are people, and the Supreme Court points out a group of people, and then in the latest New Hampshire case, the judge follows the Supreme Court order, uses that putative class, and certifies the class on the basis of facts presented to the court. So I want to start first by reading you an excerpt of the Supreme Court order that essentially curbed the district court's power to issue nationwide injunctions. While it did that, the Supreme Court did, however, made expressly a comment that gave district courts the way to move forward, which is through class actions. The opinion of the Supreme Court in the U.S. Trump versus Casa case reads as following. Rule 23s, which is class actions, as Federal Rules of Civil Procedure, Class Action Rule 23. Limits on class actions underscore a significant problem with universal injunctions. A properly conducted class action, we have said, can come about in federal courts in just one way, through the procedures set out in Rule 23. Yet, by forging a shortcut to relief that benefits the parties and non-parties alike, universal injunctions circumvent Rule 23's procedural protections and allow courts to create de facto class actions at will. Why bother with Rule 23 class action when the quick fix of a universal injunction is on the table? The principal dissent's suggestion that these suits could have satisfied Rule 23's requirements simply proves that universal injunctions are a class action workaround. Well, what the court here says is that you are trying to replace the judiciary's already vested power under Rule 23 and issue a nationwide injunction, universal injunction, instead of going about it the way that it is set out in Rule 23 of Federal Rules of Civil Procedure. So in the New Hampshire case, the district court says the following. So it certifies the class of people by going through the factual analysis provided to the court, and it says under Federal Rules of Civil Procedure 23A and B2, specifically, petitioners have demonstrated that one, members of the proposed clause are so numerous that joinder is impracticable, means there are so many people who are across the country being deprived of their right of birthright citizenship by allowing Donald Trump to keep that order going. Number two, there are questions of law and fact common to the class, so it is stemming all from the executive order banning the birthright citizenship of children born in the United States. Three, claims of petitioners are typical of claims of the class members. They're all the same claim that they have birthright citizenship when they are born in the United States. Petitioners and the council are as representatives of the class and four, petitioners and their council are representatives of the class will fairly and adequately protect the interests of the class. So the adequacy requirement that the attorneys representing the plaintiffs can provide representation. Additionally, this court provisionally finds that respondents have acted on grounds generally applicable to the class in its entirety, thereby making appropriate final injunctive and declaratory relief for all class members. This is a provisional certification, and final relief is not granted at this time. So this is a preliminary certification in order to grant the temporary restraining order in applying Donald Trump's illegal birthright citizenship order. In light of the above, this court grants petitioner's motion and provisionally certifies the following class for purposes of preliminary injunctive relief. All current and future persons who are born on or after February 20th, 2025, where, one, that person's mother was unlawfully present in the United States and the person's father was not a United States citizen or lawful permanent resident at the time of said person's birth, or two, that person's mother's presence in the United States was lawful but temporary, and the person's father was not a U.S. citizen or permanent resident at the time of the person's birth. So these are the people, this is the putative class that the Supreme Court ruled on, and this is the putative class upon which the class action is premised. And anybody who falls into these two categories, it's specific enough, it targets the order, Donald Trump's executive order, and it says that, no, you're going after these people's birthright citizenship, and we are forming a class, and you may not, you cannot, you shall not stop these people from their right to be birthright citizens upon birth. Okay, now that is what the ruling is from the district court. It will go up on appeal, and it will reach the Supreme Court again, where I believe that the government will bring up the procedural issue and ask the Supreme Court the question and present the issue as the certification of this class was not properly made. I believe if there's any appeal that goes up from this order, it will be there to attack the class action certification, because the class action, there was no sort of discovery and there was no hearing on the substance of the matters, but the court did have all the information. The court got all the briefings, and the court has made fact-finding in this case. It's a preliminary provisional fact-finding, and it stops the order while the case moves forward on the substance of whether birthright citizenship can be rescinded, which it cannot be rescinded. And it takes me back to something Judge Sotomayor said. I don't know if the oral arguments in this case or another case, because Donald Trump, the issue at hand, the reason why even a nationwide injunction would work, according to Justice Sotomayor, is because the executive order is going after and attacking an established enumerated constitutional right under the 14th Amendment of the Constitution. And when such a right that applies to as many people as qualifies, like birthright citizenship, as many people that are born in the United States, since the order was issued on February 20th, it includes all of those people, because birthright citizenship is a constitutional provision that protects all those people. And if you don't include the people in this putative class, as pointed out, you are depriving hundreds and thousands of kids of their constitutionally vested right when they are born in the United States. And they are subject to the jurisdiction thereof because their parents have been in the United States. They're being delivered in the United States. They are, when they take their first breath, subject to the jurisdiction of the United States. And so, because it is a constitutional matter, because it is a constitution that the executive order directly contravenes, even a nationwide injunction would work. But in this case, it's a class certification, and the class certification follows Justice Coney Barrett's majority opinion in Trump v. Casa, and forgets about the nationwide injunctions and goes with the class certification, which is a procedural and statutory process that involves fact-finding by the trial judge. And in this provisional order, the judge grants them that injunctive relief based on this class. But don't forget that the underlying law that is being broken by Donald Trump's executive order is a direct enunciation from the Constitution of the United States. Same goes for the illegal detentions and arrests that violate the 4th and 5th Amendments. And so, nationwide injunctions in that, under Sotomayor's reasoning, would work. But the stronger case is to go through class actions. And that's why we saw that recently there was I think the Central District of LA federal judge certified the class of LA residents and organizations that sued the federal government for their unconstitutional actions in violation of the 4th and 5th Amendment and several statutes. So with that said, I hope I have clarified for you where we stand on birthright citizenship right now. The District Court of New Hampshire has certified a class, a putative class that the Supreme Court pointed out, and has taken up the Supreme Court's order and complying with Federal Rules of Civil Procedure 23 and created a certified class and then granted relief to that certified class for a preliminary injunction to stop Donald Trump's illegal order. We're going to see what happens in appeal. I believe it'll be difficult for Donald Trump's government to argue that it falls within the certification rules of civil procedure, but they're going to argue that the certification wasn't properly made, and you cannot certify a class preliminarily to, offer this sort of broad injunctive relief. But the Supreme Court has said that you can use Rule 23. So we're going to have to see what the Supreme Court does in this case. As I've said many times before, the Supreme Court can do whatever the hell it wants. So let's see if they do that. Again, I doubt that if the Supreme Court does that they will actually get to the substance merits of the case, because I don't think that the government is brave enough to bring the merits of the case before the Supreme Court, especially at this stage when nothing has really been adjudicated and there has not been a final ruling on the substance of the issues in front of the district court, the fact-finding court. So thank you for listening. Keep an eye out, and I will talk to you soon.